So, my lords, currently water companies can violate rules and legal limits to sewage dumping ad infinitum. They can easily do cost-benefit analysis and see that it is cheaper to pay fines for illegal practices rather than investing in infrastructure and acting responsibly. This boosts profits, dividends, and executive pay, while the public picks up the cost of unplugged leaks, sewage dumping, health hazards, destruction of biodiversity and marine life. To some, such costs are just externalities, but the public sees it as abuse, as clearly shown in yesterday's mass demonstration in London. The puny financial penalties have not curbed the predatory practices, and the Minister is promising us that there will be more and saying, well, the executives may be prosecuted. That is, if they can wait another 20 years to have their case heard. There's already a backlog of 60,000 cases in Crown Court. So the result is that the whole industry is now under the control of entities which have criminal convictions. Wastewater companies in England and Wales have been convicted 1,109 times since 1989. The dismal roll call is that United Utilities has 205 convictions, Thames Water 187, South West Water 174, Anglia Water 128, Yorkshire Water 125, Southern Water 119. Perhaps the Minister would care to name a pristine water company. Never mind pristine water, just a water company. A name would be helpful. There are no pristine companies, no honourable companies, no responsible water companies, no ethical water companies. Yet successive governments continue to indulge them, give them a monopoly of an essential public good. Now, what would happen if 10 major food or medicine companies were convicted of 109 crimes which they knowingly committed? They would be shut down, consumers would sue them, but regulators in water industry do no such thing. Indeed, ministers make excuses. Successive ministers have done nothing. So my amendment requires that habitual offenders be placed into special administration if 2 or more criminal convictions are secured in a 5-year period. This is akin to a yellow and a red card in football. The first yellow card is a warning, effectively saying, don't do it again, mend your ways, clean up your act. But if no heed is taken, then the second yellow card, which is effectively a red card, follows, and the companies would be placed into special administration. It is often claimed that shareholders are passive. Well, the threat of special administration for abusive practices would encourage them to actively invigilate companies and their boards and take interest in the governance of companies. So for far too long, companies have got away with abuses. My amendment would ensure that there are serious consequences for them. If the Minister does not accept my amendment, can she say how many convictions do water companies actually need before they are considered to be unfit and improper to own crucial infrastructure?